closing your business won't make lawsuits disappear. While many business owners believe dissolving their company will shield them from legal claims, the reality is more complex. When a business closes, it doesn't immediately cease to exist in the eyes of the law. Most states have statutes that allow a dissolved business to continue existing for a period, specifically so claims can be settled. This means creditors, customers, and other parties can still pursue legal action against your closed business. Proper dissolution is far more involved than simply filing paperwork with the Secretary of State. To truly limit your liability, you must notify all creditors and stakeholders in writing, pay outstanding debts including taxes and wages, cancel permits and licenses, file final tax returns, and distribute remaining assets according to legal priorities. Skipping any of these steps leaves you vulnerable to lawsuits even years after closure. Following your state's dissolution notification procedures precisely is crucial. Many jurisdictions allow you to limit the time frame during which another party can sue you, often to about 3 years after dissolution. However, failure to follow these statutes can extend that period significantly. This is why maintaining organized corporate records, even after closure, is essential. Attempting to close a business specifically to avoid a lawsuit can backfire severely. Courts examine the timing of your closure relative to claims, look for signs of fraudulent intent like hiding assets, and scrutinize whether you followed proper dissolution procedures. If a court determines you closed your business to dodge legal responsibility, they may pierce the corporate veil, allowing plaintiffs to pursue your personal assets. Businesses commonly face lawsuits after closing for several reasons. Unpaid debts prompt creditors to pursue the business for outstanding balances. Breach of contract. Claims arise when former clients believe agreements weren't fulfilled. Product liability or negligence claims can surface years later, especially within applicable statutes of limitations. Internal disputes between business partners over profit or asset distribution can trigger litigation. And employment law violations regarding unpaid wages or wrongful termination don't disappear when operations cease. Personal liability after business closure depends on several factors. If your business maintained good standing with regulators, had no pending lawsuits at dissolution, and followed all statutory dissolution steps, your personal exposure is limited. However, you may still be personally liable if you signed personal guarantees on business debts, failed to separate personal and business finances, committed fraud or gross negligence, improperly dissolved the business, or continued operating under the business name after dissolution. To protect yourself when closing a business, consult an attorney before initiating dissolution to assess outstanding liabilities. Resolve all known debts with vendors, creditors, landlords, and tax agencies. Formally notify all stakeholders about the closure. Document everything from communications to payments and final filings. Consider purchasing tail insurance to cover claims made after closure. Avoid suspicious transactions like transferring assets without fair market compensation. And ensure all federal, state, and local closure documents are correctly submitted. The key takeaway is that closing a business requires careful legal planning. Proper dissolution procedures can significantly reduce your risk of future claims, while hasty or improper closure can extend your liability for years. When in doubt, working with an experienced business attorney provides the best protection during this complex process.